we get the opportunity, we'll take it in another discussion because time will not permit us. So I want to discuss first and foremost the importance of this topic. Most of the time, people take contracts of employment and the first thing they go to is their remuneration. First and foremost, they just want to know how much they are being paid. Every other thing doesn't matter to them. But you realize that where employment terms are not defined, where a contract doesn't exist between parties to an employment situation, issues arise later. And as a church, we usually have people starting companies and businesses. They have people working for them. From the start, we don't define these relationships, but they come back later to bite us. It might look like an exercise in futility or you are wasting your time. But in practice, you realize that whatever you leave undone now by law will come back in the future to bite you. So it might look like it's not necessary now, but it is better to define the relationships you have with people working for you. You might probably just have started a business with your brother or sister, but under what circumstances are you working together? If the company starts growing, what are your positions in the company? You'd realize that people have worked with companies for so long, worked with them from the time they started, but they probably didn't have certain qualifications to work in certain roles. So as the company grows, you find that the company needs to employ people with qualifications to work in these roles. And people who have been there for long will now have to report to new hires or new employees. And it makes the situation very murky and very unpleasant one. So you would want to have governance structures in place right from the beginning. You would want to have employment structures right from the beginning, reporting lines, and then the order of employment in your companies. No matter how little the company is, you may need it. So what's the legal framework for employment in Ghana? We have first and foremost our constitution, which guarantees the freedom to have any undertaking you want to as a human being, your freedom of association. We have the Labor Act, which is the primary regulation for labor in Ghana. We also have the labor regulations. The difference between an act and a regulation is that it's like mathematics. We have the mother set and then we have a subset. The mother set is the act, and the regulation is just a subset of the act, providing for additional matters that were not mentioned in the act itself. We also have case law. So there are a number of instances where labor acts do not speak to certain matters or are not very clear. They are ambiguous. Everyone can give their own interpretation to it. So you see a particular provision in the Labor Act and party A is giving it one interpretation and another party is also giving it another interpretation. They both may be right, but then it takes only the court to decide who is right in that situation. And that decision of the court becomes the new law and it is binding on every other subsequent matter. We have several other laws that come into play when we talk about labor. We have the Pensions Act, we have the SNIT Act, we have the GRA Act, immigration laws, and several other laws. But today, that will not be the focus of this discussion, so I will not go into detail with them. Employment status. When you want to enter into an employment relationship, we have two statuses in that regard. We have what we call contract of service and contract for service. They mean different things and they have different legal effects, different incidences or benefits and all of that. So if you want to enter into an employment contract with someone, you need to know whether it's a contract of service and a contract for service. So a contract of service is the normal employment contract that we have. So an employer and an employee in an undertaking or a company. And then we have the contract for service. A contract for service usually is the independent contractors. So you are merely contracting someone to come and perform a service for you. So maybe an air condition repairs company or person. So that is just a contract for the provision of services. and does not qualify as an employment contract between an employer and an employee. So if you need to get someone to perform certain services for you, you need to decide, am I bringing this person on board as a contract of service or employment, or we are bringing them on board for just a contract of service, and when we are done, they can go. I will talk about the legal effects of these two distinctions. So when we get there, we'll talk about it, and then we'll see why we need to classify our employment contracts based on these two distinctions. We have what we call hiring options or forms of employment in Ghana. Others call it types of employment. It doesn't matter the label you decide to give to it. But if you are employed under the Labor Act, you are employed under either three of this. We have temporary employees, we have permanent employees, and we have casual workers or employees. So talk about the temporary employees. You have someone working for you for at least 1 month, but not more than 6 months. So between 1 month to 6 months, you have an undertaking that you want to perform. You can employ someone on such a temporary basis, or you have a role you have to fill in because your substantive employer in that role is not employee in that role is not around, and you need to fit in someone to take up that role. You can consider a temporary employment or a fixed term employment. It is for a particular duration, which is that it is not less than 1 month and it is not more than 6 months. So you probably need a nanny or a house help. You can decide how long is this person coming to stay with me and put the person on a temporary employment basis. We also have what we call permanent employment. These are employment situations where there's no definite duration. So there's no fixed period for this kind of employment contracts, which most of us are on. So you are just employed indefinitely and you are in the employment of the employer for as long as both of you want to stay. We also have what we call casual employment. This is very common in Ghana. These are usually intermittent or seasonal workers. So you'll usually find these people in the construction industry, usually in the informal industry as well. So you find people being employed on casual basis. People don't know that that is what we call casual employment, but that is the legal term for it. They come in and out. They come because it is the season for something. So they come in, for example, in agriculture, it's time for planting. So you find people to work for you and just plant for you and go. And then it's time for harvesting. You go for those same people to come and harvest for you and go. That is an employee-employer situation existing there. But you have to take note that these casual employees should not be in your employment for more than 6 months. So if you are a contractor and you have taken up people to work for you on a construction project and you want them to work for more than 6 months, it will not be a casual employment. Or you forget that you have a 6-month contract with them and then they work a day more than 6 months. Once the period is more than 6 months, it automatically becomes a permanent employment situation. And you need to take note of this because of the protections that are offered all these types of employees under the law. Okay, so the same situation also applies with temporary employees. If a temporary employee is under your employment for 6 months and they do more than 6 months and you do not renew the contract with them, after 6 months, they become permanent employees. And the incidences that are afforded them in the Labor Act now applies to them as permanent employees, right? So please take note when you are employing as an employer. Is the person a temporary employee, a casual employee, or a temporary employee? If they are, ensure that if they are temporary employees, they do not work for more than 6 months. Otherwise, you are taking up more responsibilities for yourself. Reasons for determining employment status. So when I discussed contracts for service and contracts of service, I said we'll come to the reasons why you need to determine these statuses. One is for tax purposes. So when you take someone up under a contract of service, the tax you are required to pay there is different from taxes you are supposed to pay under a contract for service. So a contract of service or an employment contract, strictly speaking, will require you to withhold tax on the employee's income. That is what we call pay as you earn, basically. So the tax you withhold there is pay as you earn on their employment income. It is different from the tax that you pay if it is a contract for service. That usually falls within the ambit of withholding tax, right, for services, not pay as you earn. So the tax obligations of an employment contract or a contract of service is different from the tax obligations for a contract for service. So we have pay as you earn, and then we have withholding tax on the provision of services. We have social security or pension contributions. Based on whether it is a contract for service or of service, you may need to pay pension contributions for the person. Where it is a contract for service, the person is an independent contractor and they are just there to provide services for you and go. So you are not required to pay their SNIT contributions or pension contributions. But where the person is your employee, you are required to remit their social security payments to SNIT. This will not be we are not going to go into details with that, but we have the 3-tier pension scheme. The first tier and the second tier, you are supposed to ensure that you pay it, which is 18.5. But then when it comes to the third tier, you have the option to either, if you are benevolent as an employer, you have the option to give that to your employees, but you are not required by law to do that. So whether or not it's a contract for employment or of employment, it needs to be decided because of social security matters. We also have employment protection rights. The Labor Act, as we have it, governs contracts of service, which is the employee-employer relationship as we have it. It does not cover contracts for service. Contracts for service. The Labor Act does not cover contracts for service. It only covers contracts of service. We have vicarious liability. It's a legal term for when your employees incur liabilities for you as an employer by virtue of they just being your employees. So if an employee is driving a company car and they hit someone on the street, you might be the one to pay for the costs or the liabilities that will arise from there. So it is deemed that whilst they are performing their duties, any benefits or liability that they incur will be for you. You obviously take the benefits, so the liabilities will also be yours in that sense. But we need to know that when the court is deciding this, or when situations like this arise, you have to consider whether the person is on a frolic of their own. In the sense that for vicarious liability, if as a company, if the company driver takes the car to just go and roam on his own, it is not working hours. He is going on an errand of his own to pick up his own items somewhere. Or it's a weekend, he's not supposed to be working. He's driving the company car and he hits someone in the process. He's entirely on his own. He was on a frolic of his own, and you cannot be held liable for that as an employer. But when it comes to independent contractors or contracts for service, there's nothing really about vicarious liability because the person is working on his own and you have just contracted him to come and provide services for you. It doesn't matter the number of occasions on which they come and work for you. Once it's a contract for services, They are not your employees. And so any act they do does not affect you as an employer when it comes to liability. Then, of course, health and safety. Anybody working for you as an employee is basically under your care once they are at work or working for you. Now we'll come to the contract of employment itself. I want to say that you don't want to go to court as an employer or as an employee with the other party without written evidence. In Ghana, you may present your case orally, but take it from me, it is your word against theirs, and you don't want to go through that. You want to have your evidence written so that in the event of anything, you have proof, which is the written proof, which is actually the best kind of proof in court. Now, what is an employment contract under Ghanaian law? It is a contract of service, as we mentioned earlier. It can be express or implied. Express in the sense that you have written it down. You have the book or the paper to show that this is our contract of employment. Implied in the sense that we haven't written anything down, but don't be too happy about that as an employee or employer, because when the case goes to court, the court might imply an employment relationship between the two of you. So you need to take note of how you deal with people that live with you or people that actually provide certain services for you out of free will. When you begin to control their hours of work, the time they work, the outputs, you pay them. It's like you are in charge of everything concerning the work. A contract of employment may be implied between the two of you. So don't be too happy that, oh, I've not employed him, he's not under my employment. The court may use other things to imply an existing employment between you. So that's they can use the facts of the circumstances. They can use statutes. They can use common law. They can use custom. Under the custom, if you have worked with someone or stayed with someone or provided the services for this person for this number of years, even though we don't have a written contract, the court may imply an existing contract between you two. And we have what we call oral or contracts in writing. Basically, oral contracts, as the name suggests, is, oh, come and work for me. I'll pay you 2,000 Ghana cedis a month. Then we agree orally. Here, it is not a fact that there's no contracts of employment, but we just agreed that you're working for me. You're working Monday to Tuesday. This is how much I'll pay you. You can take your leave once a year and all that. You can prove it. But as I said earlier, you don't want to prove an oral anything in court because it's your word against theirs. So you would want it to be in writing. Now, how can the parties to an employment contract make changes to an existing agreement? So where you work for an employer, so employees and employers, if we decide that we need to make changes to our employment terms, so maybe I want to change the time you close. I want to change the amount of money I pay you. Or as an employee, I think I'm growing old, so I want to reduce the hours I work. I want to close at this time. Or because of this project I'm doing, it's you want to change the terms of your contract. You cannot do that unilaterally. You can't sit down and say, I've changed the terms of contract, so these are your new terms. It took the two of you to make the terms. So definitely it takes the two of you again to sit down and change them. So basically your employer needs your consent to change the terms of your employment contracts. Must an employment contract be in writing? As I said earlier, you'll be doing yourself much good if you put it in writing. And the act itself says that, yes, it must be in writing unless it is less than 6 months. So that is why you find casual employment not necessarily needing employment contracts because they are less than 6 months. So it doesn't need to be in writing. But once it is more than 6 months, you need to put it in writing. Then again, You can't say because the act says it must be in writing and our relationship is not in writing, I don't have an employment relationship with you. The court will infer an employment relationship. That is why when the act was defining it, it says either oral or in writing. So yes, it must be written, but where it is not written, the relationship will be implied. Now, we'll consider the key provisions that we are supposed to look out for in a contract of employment. There are several things that you can look out for in the contract of employment, but I'm not going to bore you with all of them or those that I think are not contentious. I'm going to go straight to the point about certain terms that I think that as a Christian listening to me right now, you should take your time to look at them. If you cannot, have your lawyer look at it for you. Because as I said from the beginning of the presentation, the first thing you want to look at is your salary. But then situations come up in future. A lot of things happen in employment situations, even between founders of companies. So you want to look at certain key provisions. That is why I have named them key provisions. So these provisions are not all the provisions you need in an employment contract, but the ones I've not mentioned, I'm sure you yourself will even look for them before I tell you how much you are paid and all of that. Your name being in the employment contract, your position and all of that. Those ones I know you very much look at them. But these ones, I want to bring them to your notice. We have what we call probation. Probation is not compulsory. Maybe I'll have to define probationary period for those who don't understand. Probation is like a trial and error period in employment. So someone has employed you, but they need you to work for a few months or for a duration for them to determine whether they want to continue to work with you or take you on a permanent base. So that is basically probation. As an employee, when they give you an employment contract, you need to take a look at it. Does it have probationary provisions? If the employer says you are going to be on probation and it is not inside, you need to ask for it. And in discussing these key provisions, I want to make a cautionary statement that this discussion is neither biased towards employers nor employees, but it is for our own knowing and our own learning as a church, because sometimes people do not bargain as an employee their employment contract because they don't even know what the law says about it. So you haven't even asked for it because you don't know. And as an employer, you haven't put it in your employment contract because you don't know. And then in future, you are saddled with a lot of issues up and down. So I'm issuing this disclaimer right now so that you know that it's for your learning and knowledge. It's not pro-employee or pro-employer. So probationary periods, as an employee, you have to look out for them to know that during this month that I'm working, I'm only on probation. So the law requires that you provide a particular duration. So that one is by statute. If you want the person to be on probation, you need to provide the duration. Someone cannot be on probation infinitely. So the person is just on probation. You've not said it's for 1 year or 6 months or 2 months. You cannot have such a probation clause. If it has to be interpreted, it will be null and void or ineffective. So you need to state the duration. However, the law does not provide how long it should be. But then again, you should be reasonable. You cannot ask someone to come and be on probation for 5 years, for 3 years, for 4 years. Exactly what is the person learning to be on probation? You are just taking advantage of the situation. So you need to determine the time or duration for the probation, which must be reasonable. The law says it must be reasonable and must be determined in advance before you start your probation period. Now, there's one key thing I want us to take note of. As an employer or as an employee, when you take your employment contract, you need to look out for the termination term in a probation contract. I have reviewed some employment contracts, and I realized that most employees or most employment contracts have the probation term in them, but they do not have a statement about termination during probation. They just go straight forward and say that at the end of probation, if we don't find your employment satisfactory, we can end the employment relationship. But what happens during probation when it's not 3 months yet, but you want to sack me because you find issues coming up for court where the employee says, fine, you said I'm on probation. You said that you can terminate at the end of probation, but I just did 1 month and you terminated my employment, no notice, nothing. In that circumstance, you did not define the terms, so they might take you on a roller coaster in court, but do you really have that time and money and energy? You don't want to go to court because of that. So you need to state it that during probation, I reserve the right to terminate your employment, but I'll give you 1 week notice. I'll give you 1 day notice. I'll give you, just put something there to show that even though I have the right to terminate it during probation, I will let you know first and then I'll terminate it. Or I'll not give you notice. I'll terminate it summarily. So that one you have put it there and the employer or the employee is aware of it. So when you decide to terminate it, they really don't have much to say, right? So please take note of your probation clauses, the duration and termination during probation. Want to look at working hours and overtime. This is a very controversial term in employment contracts, right? But you want to take notes. If you are negotiating your employment contracts, you may want to discuss this before you start working. The usual standard maximum working hours in Ghana is 40 hours a week. That means 8 hours a day. So in a day, if you are going to work at 8 a.m., you should close at 4 p.m. If you are going to work at 9 a.m., you should close by 5 p.m. So that's the usual working hours that you are supposed to have in your contract of employment. And between all of this, you are entitled to 30 minutes break. So if your employer is giving you 1 hour break, please go and say thank you. He or she is being generous because they are entitled to 30 minutes. Unless you are working in a shift system. Those who work in shift systems like the nurses and doctors and all of that, they are entitled to 1 hour. But if you have 1 hour, go and say thank you. Now, what are the minimum requirements relating to overtime? So as I stated, you're supposed to be working 9 to 5 or 8 to 4 p.m. or 10 to 6 or 11 to 7, whatever the time is. It's 8 hours. Anytime you work beyond that is considered overtime. So when you take your employment contract, go and look for your working hours and overtime payments. The employer is supposed to state that anytime you work beyond these office hours, it's overtime, and I'm going to pay you so and so. They are supposed to provide a rate for overtime payments. So if you work beyond 5, each hour the rates will be, say, 50% of your daily wage or your daily payment, or 100% of it. If you come and work on a weekend, 200% of how much I'm supposed to pay you that day. So you must have a rate for it. Usually you find employers lumping up that clause that, oh, your salary includes overtime pay. That is wrong. They are supposed to state clearly the rates for that calculation. And at the end of the month, they're supposed to add that to your salary. So if I were you, next time I'll go very fast to that particular term in my contract of employment before I sign. I know it is hard to bring up these issues because usually employers have a higher bargaining power when it comes to employment in Ghana, especially. But you would want to try your luck. It's better to know and ask for it than not know and not say anything when probably your employer would have gone ahead to do that for you. Non-termination. This is also a very controversial topic. This might even take a whole presentation, but I'll try to talk about it briefly. The major things you should look out for. Please read the termination clauses in your contract of employment. Employers, please put termination clauses in your contracts of employment and let them be definite and clear. Don't leave any ambiguities surrounding them. an employee, look for it and know how I can be sacked from this employment, and know how the day that will come and they can tell me that I should leave. Look for your termination clause, right? Now, under Ghana law, we have what we called slavery or servitude. Nobody is required to force anyone to work for them. And nobody is supposed to retain anyone. So if you're an employee and you think your employer cannot sack you, you are joking. And if you're an employer and you think your employee cannot leave, you are dreaming, because we don't have contracts of servitude in Ghana. If it is time and the employee or the employer says, go, you have to go. And if you're an employee and you want to go, you can go. Nobody can force you to stay. That is the law generally. But then you need to terminate that employment contract in accordance with the law. That is the Labor Act, or in accordance with your contract of employment. So if you don't have termination clauses about termination in your contract of employment, and then you terminate it anyhow, and then later a court or the Labor Commission finds out that you terminated it in a way that is contrary to the provisions in the Labor Act because you don't have a provision on it, then you're in trouble, right? So you would want to discuss all of that. One thing you need to take notice of that we have notice periods. When you want to terminate a contract of employment, you need to give an employee notice. You can't just stand up today and say, I'm terminating the employment. So always have notice periods in your termination clauses. Usually you review employment contracts and you realize that they provide for termination, but they just say either party can terminate this employment contract. It is not complete. You are supposed to terminate by giving notice, and these notice periods are dependent on your duration with the employer. So for example, if you've worked for 3 years or more, they're supposed to give you at least 1 month's notice. So in the employment contracts, if you see 3 years or more, and the notice period there is less than 1 month, it is against the law. It's 1 month if you are there 3 years or more. If you are there less than 3 years, it is 2 months notice. But if you work week to week, then it is 7 weeks notice. So please take care of the notice periods when terminating. Employers, take notes and put it inside. Employees, look at it for your own safety. Now, we also have what we call reasons for termination of employment. Under Ghana law, an employer is not supposed to tell you why they are terminating your employment. It is not mandatory. If the employer wakes up and say, I cannot work with you again, so in a month's time, please leave, that is well within their rights under the law to do. And if an employee says, I think I want to go, I think I want to move on, or I don't want to be here anymore, that also is within their rights to go, and they don't have to give you reasons. So there's this controversy online that you need to, I saw something on Twitter where some HR personnel was advising someone that no employer has the right to terminate your employer without giving you a reason, blah, blah, blah. That is not true. They can terminate without a reason. And as an employee, you can't leave without telling them the reason why you are leaving. Maybe if you have goodwill with a person, you might want to say, oh, this is why I'm leaving, blah, blah, blah. But as an employer, you would rather stick to just terminating and giving notice than giving a reason, because you are at risk of being sued for that reason. And you know, grounds of termination, the person will come later and say it was unfair. So you are better off just saying, go, I don't have a reason, than giving a reason. You also have what we call grounds for termination. Usually just make sure that you have the grounds for termination, and those grounds should be in accordance with the Labor Act. Otherwise, they will be unfair. We also have termination versus misconduct. In your employment contracts, under the law, termination and dismissal for misconduct are two different things. So your employment can be terminated and you can be dismissed. They both mean different things, and the incidences of both are different. The benefits that come with both are different. So for example, when you are dismissed, certain benefits that are due you will not be given to you. You are dismissed. So it's like a punitive action. or when you are dismissed, it can be done instantly. That's a summary dismissal. Immediately, we've caught you stealing. You have to leave our employment. So you have to distinguish between these two. Don't make them overlap. Give some for termination and then come to misconduct. In this company, if you do this, we'll summarily dismiss you. If you do that, it will warrant a dismissal. Have clear provisions on those things so that a situation doesn't arise and then you are all now thinking, does this warrant dismissal or summary dismissal? Now you are even confused as the employer yourself. You don't know what to do. So state it in it and have it documented. We also have termination benefits. As employers, you can state it in your employment contract. If I terminate your employment, I'll give you 1 month salary for each year worked, blah, blah, blah. Those things, I'm sure your finance department will take care of it for you. But always have termination benefits stated in your employment contract. It just makes it easy. And we have non-compete clauses. I will come to that later in the discussion. Now we have leave periods. I'm sure a lot of us have been working and we already know the leave period that we are entitled to. Apart from those in the public sector, we know that the minimum leave duration you're supposed to get is 15 working days. We have maternity leave for women, which is at least 3 months or 12 weeks. We have compassionate leave. That is where you probably have lost a loved one or someone is sick, you need to take care of the person. You can go and ask for compassionate leave from your employer. We also have sick leave. Always check out for the sick leave provisions in your employment contracts. They are not supposed to form part of your leave durations. So if you are sick and the employer says that you've stayed at home for 2 days, so I'm subtracting it from your leave days, it is not right. They are not supposed to do that. And usually when it comes to sick leave too, you might want to look out for payments during sick leave because there are certain sicknesses that will take months and probably even a year or years. They drag on, and some employers might want to use this as an opportunity to terminate your employment. But then when you are negotiating employment contracts, watch out for your sick leave. The employer too, you may have to put terms inside that if you are sick for a year or for 6 months, I'll pay you your salary for the first 4 or 5 months, I'll pay in full. Or for the first 6 months, I'll pay in full. After 6 months, I'll pay 80%. After 1 year, I'll pay 50%. You should have provisions in relation to that because you find employees falling sick for a year or something, and the employer will say, I'm not paying you your salary again. So please, you might want to take a look at this before you sign that employment contract. Disciplinary and grievance procedures. Please have that. And employees, please look out for that. If you have a problem, who are you supposed to report to? How are those issues supposed to be handled? You don't leave it for one person in an organization to be taken care of. You should have strict and clear reporting lines in your company or as an employer. If something happens, who is the person supposed to talk to? If it is that person that is actually the reason why I want to report, who else can I talk to? Clear governance structures. So that, for example, for issues of dismissal especially, you would provide that when we find you, say, in a sexual harassment situation, we are going to take you through disciplinary process. But where is the process? Have they written it there? So that one day they don't come and take you through some processes that you are not aware of, or you've not even envisioned that is how it will go through. Or the employer doesn't have it. So the thing happens and everybody is now looking for how we resolve such issues. So as an employee, you would want to look out for this. If there's a company that doesn't have disciplinary and grievance procedures, please inform them to put it in place, or for you should put it in your contract of employment, because you would want to know who to report to and you'd want to know what will happen afterwards. So for example, the company will say that after the investigation will take, say, 6 months. After that, if you are found liable, we would suspend you, we will dismiss you. During the period of suspension, we'll pay you half your salary, or during the interdiction, we'll not pay you at all. All of that, please have it in your contract of employment. Then we have intellectual property. I put this here because of our Gen Z community now. You find a lot of artistic aspects of companies, the graphic design aspects of companies, intellectual property issues come up. You are probably a singer, you sing in the company, you design stuff for them, copyrighted materials and all of that. You would want to decide what kind of materials, or even if you are in the science field or the IT field, what type of work will I do will belong to you as an employer. If I'm sitting in the comfort of my home and I develop an app, would you say it is yours because I am your employee? You would have to state all of that. If within that whole duration of your employment, anything you develop belongs to the employer, it must be stated. So if you are an artistic person, or if you are in this field, you would want to take note of that. Whether it is any and all types of work that I produce during my time with you, or it is when I'm at work, or when it is work related, that it will be for the company. Please take note of such provisions. If it is not inside, please recommend that it be put inside. And then we have what we call redundancy. Under Ghana law, apart from termination and dismissal, we have what we call redundancy. You can become unemployed because of redundancy. Redundancy occurs where a company decides to change major production lines. So for example, we were producing drinks, and then all of a sudden we say we don't want to produce drinks again, we want to produce fabrics. It means those working in the drink section of the factory might have to lose their jobs, because we now need people who can produce tie and dye, and not people who can brew Guinness or malt. So in that circumstance, there will be a redundancy, or probably the organization is shutting down. They are ceasing to exist. There's restructuring and all of that. We have, for example, the USA, right? When Trump came, they said they've shut them down in Ghana. A lot of people became unemployed because of that. So you want to take your employment contract and look at it. If all of these things happen, what would my employer do to me? Like, how am I supposed to survive after that redundancy? We have what we call redundancy pay. They're supposed to negotiate a pay with you. Ask the employer how they will treat you when that time comes. Some employers will actually look for an alternate employment opportunity for you and put you there. Ask them, are you just going to let me go? How are we determining the severance pay? Some employers will say, in this field, we do 2 months salary times each year worked, for each year you've worked. So if you've been with the company for 20 years, now the company is ceasing to exist, they'll pay you 2 years salary times 20 years. And then they'll add it to your redundant pay. That's what we call the severance pay. You need to look at the terms and everything that comes with the redundancy. Usually it fastens the process when you get to that place. You are not now coming to have a legal banter to determine those things, because you have predetermined them. And then you just go into negotiation stage to just calculate those things. We have restraints of trade clauses. These clauses will usually say, if you leave my employment, don't go and work for my competitor. So don't go and work for my competitor for some number of years. Some will even say, don't go and work for my competitor at all. But you need to look out for that as an employee, because it would affect your employment capacity or situation after you have left the company. Okay, so you are looking, the courts will usually enforce it when it is reasonable. So your employer cannot say, when you leave my employment, don't work for my competitor for 7 years. Even 5 years is a lot. So such terms should be reasonable. You want to look out for it before you sign it. So please look out for restraints of trade clauses. If they are not there, don't raise it because they are not there, because this is like an employee, it's like a disadvantage for the employee. So if it's not there, there's no need to put it there. You might want to mention that they put it inside, that there's no restraint of trade after you've left. So that after you've left, they will not come and be making claims of you having confidential information. that the company had because you were in employment with them. So you may put it there. Let it be clear that there's no restraint of trade when I leave your employment. Or as an employer, you want to put it there for 1 or 2 years or for 6 months. When you leave my employment, you can't go and work for my competitor. Please take notes. In practice, these are real issues. You find an employee leaving their employment, and then the next day they are in your competitor's office working. Depending on the trade and the sensitivity of the employment, you might need to put confidentiality clauses and restraints of trade clauses in your employment contracts, or get yourself protected from them as an employee. Now, before 2020, most of our domestic workers were not regulated, even though they were supposed to be regulated. People treat domestic workers, people basically exploit them. Let me use that word. However, after 2020, it is no longer the case. So now if you have a maid, if you have a nanny, you have a gardener, a driver, a gatesman, all those domestic workers, the law requires that you have employment contracts with them. Now, those people have been recognized as employees by law starting 2020. So this regulation was passed, the labor, that is the Domestic Workers Regulations 2020, LI 2408. The purpose of this regulation is to protect domestic workers. The law is very pro-employees, so it is to protect employees who are domestic workers, and also to define the relationship between domestic workers and their employers, because people don't even understand the relationship that exists between them. So this law has come to settle that position, that you have an existing employment relationship between you. If you don't have an employment contract, the law will infer it, as I already stated. Now, what are the categories of domestic works? We have domestic chores performed in any home or domestic setting, informal work performed by a worker who also performs household chores in the home of an individual, assistance in petty commercial activity, security services, and gardening. Please give me a minute. I would want to read the second schedule of the Act. It actually lists the various domestic works strictly. So it says child minding or babysitting. So and then taking care of the aged people who perform general household chores such as cooking, marketing, laundry, ironing, removal of refuse, setting and cleaning of the house, any other household chore. We have drivers, gardeners, security personnel, assistants in petty commercial businesses like food processing, preparation and sale of goods, baking and storekeeping. So all those people so let me take, for example, the watches sellers, all those people helping them, washing their bowls and helping themselves. Under the labor law, they are employees now, unless you have them on a casual basis and they can go at any time, or you not want to treat them as permanent employers. Otherwise, the law now recognizes them as your employees. And since that is the case, you need a contract of employment for them if they are going to be with you for more than 6 months. And in this employment contract, all the terms that we have discussed right now must be addressed. Termination, hours of work, remuneration, overtime pay, leave, and all of that. You need to take care of all of that in the contract of employment. So in the formal sector, just as you look out for those clauses in your contract, now the nanny has the right to also look out for those terms in their contract of employment. And after that, you're supposed to deposit it at the appropriate district labor officer's office. After entering the contract, please deposit it at the appropriate district labor officer's office. And then also have termination clauses in these contracts of employment. And please have these contracts of employment, because if anything happens, it's the word of that nanny against yours in court. Thank you very much. Please, any questions?
Thank you so much, Sister. Please, questions. Okay,
Hello.
we
Hi,
have-
good evening.
Good evening.